Great. Hi, I'm Tanvi Muralidharan. So I'll be taking the last session in our three-session contracting do's and don'ts presentation. So this will be a fairly casual session. You can keep asking questions because mostly what we are going to focus on is case studies and templates. Without further ado, I'll just quickly delve into the topics. So as I discussed, like we are in the session 3 and the last session. So what to expect out of this session is that what we have done is that we have taken certain clauses like force majeure, IPR, dispute resolution, notice and amendment, which we find that, significantly that a lot of business teams grapple with because there are changes in this and you don't know what to do. And then, to take it back to the legal is a time consuming process in a lot of cases. So we'll quickly tell you what you need to be aware of these aspects and why these are relevant. So those would be the case study part of it. And of course, whatever questions you have kept at abeyance from your previous sessions, you can take that up this session, and then you can ask that during anytime during the presentation, if that is fine. And then quickly about this one feature in our LawKNIT Virtual, which is a proprietary platform. So we do have a lot of templates that is downloadable on our portal. So once you log into our portal, you will get access to those templates, and then of course, since it's a template, you just need to add in the relevant information as to the party names and other information. Like if it's a service agreement, you can just add the scope, and then you can use those templates. And we are also going to be launching a automated drafting of contract feature. So wherein you can just fill in the information on the go, and then it will create a template for you for cater to your specific needs. So these things we will get into. I mean, if somebody wants a demo or something, you can just reach out to us for the same. So I'll just start with the first clause that is relevant, so which is force majeure, which I think a lot of people would have heard about during the pandemic. Right after the lockdown is when this clause really blew up. Everybody came to know about force majeure. The major reason why this was so relevant then is because usually once you enter into a contract, that means you are sort of bound by that contract. You're tied up to that contract. Okay, there are very few options for you to get away from the contract without really getting the other person's permission. One of those methods is essentially force majeure. Force majeure, but it's not something that you can create or cultivate, because force majeure essentially means act of God. That means it has to be something that is beyond your capability or beyond your responsibility. Okay, so here there are a few aspects of these clause that is relevant. So I've just marked those out here. So here the performance of that particular person, like if it's a two-party contract and one party is actually providing services and the other party just is paying for those services. So the service provider's performance has to be hindered by certain things. So those certain things are what is highlighted in red, and what those certain things are, you have to clearly mention in the contract. Okay, so here this has to be prevented. A person should be prevented from doing something because of these actions. And these actions are always something that is beyond the ability of the service provider or the person performing the contract. So that is why, if you can see, it is riots, civil commotion, insurrections, rebellion, pestilence, epidemic, pandemic, government action, war, hostility, forces of nature, lockouts, acts of any governmental authority. So these are all actions beyond our control. So that it has to be beyond the control for it to be considered as a force majeure event. And then the second thing, so now you have defined what a force majeure event is. So the next question that comes up is, what happens when a force majeure event happens? So this you have to tailor make it to the contract, obviously. However, in most cases, what will happen is that you will either get an option to actually extend your term to complete whatever is required under the contract, or you will get an option to terminate it. Okay, so this is a general, that is what you can see in the second part in the last slide. So, and you need to mention for how long this force majeure has to go on. It shouldn't be like, just there is 2 days ka delay and then you can terminate the contract. That just doesn't make sense. So it needs to be a reasonable time period. That is what 30 days usually is, like some 30 to 60 days is the average across board. But of course, depending on the type of contract you are entering into, you can obviously make those changes there. But you should definitely say what period and what is the consequence of a force majeure. Otherwise, this clause is ineffective. So I'll just quickly take you through some case studies also in this case. So the first one is where a company is in a manufacturing sector, and then they took an order and they're unable to deliver the goods because there is some sort of a lockout in that means the workers are not cooperating. They've just locked out the factory and they are not working. So as a result of that, whether this will become a force majeure or no is a question. So then we'll have to go back to the clause now. So we need to see whether the word lockout is actually there in the contract. So you can see that the lockout is there next to strikes and lockouts before acts of any governmental authority. So lockout is a reason why they can trigger force majeure, and as a result, any delay that they have caused in delivering the goods will sort of get waived off because of this particular scenario. Okay. And again, the thing is that you need to ensure that this delay is like over 30 days and all of those things. Otherwise, you don't get that option of claiming lockout. So here, because that word is there and it is beyond the control of the management, it was considered as a force majeure. Now, then another situation is also that in case let's take the example of an agreement between two parties where there is a EBITDA based formula, and in that case there is a governmental change in policies. Okay, there is a change in governmental policies, due to which what happens is that the company's business is no longer viable. For example, you would have seen there was an entity initially which plied basically bike taxis long before. Now it has become legal. Earlier there was an ultimatum from the government saying that these bike taxis were not legal, and as a result of that, a lot of companies had shut down at that stage. Okay, so now if let's say they were required to transfer the shares at the value of that company at that stage, and this other entity who has entered into that contract essentially could buy cheap because the valuation has gone down, right? Or let's say they're required to buy that company at X valuation, okay, but the valuation of the company has gone down. Would they still be required to do? So here we'll need to look at what the actual action of that two parties are. The action of the parties that they need to take is one person has to sell the shares and the other person has to buy the shares. That is not stopped from governmental policy change. What the governmental policy change in fact triggered is that the valuation of the company has gone down. Nothing else. The sale of shares is not prohibited as a result. So it was deemed that this will not be force majeure because the act of the parties are not really hindered in any way because of these change in governmental policies. So here from these examples and from our discussions, how do you distinguish force majeure? Okay, what are the differences? In the first scenario, what we can see is that the action of the party is actually hindered because of the force majeure event. In the second one, that is not. And in the other thing is that even though the governmental change in governmental policy was part of the force majeure item, or force majeure list, it will still not be considered if the acts of the it is not beyond the control of the parties. They can still perform the contract. Okay, and another thing is also that you need to ensure that these words cover almost all scenarios that is relevant for you. And if you're on the other side, you need to make sure that these words do not in fact add more things to it. So in one of the contracts I've seen inability to pay as one of the force majeure events. That means you would take care of the entire service and the other person could just claim that we are unable to pay now because our customers have not paid us and things like that. So that is incorrect. That is not a right usage of force majeure event. So you need to be very particular about looking what these terms are and how they are used. Second common clause that like almost all the business units always comes back to us is with respect to dispute resolution clause. So there are only very few items in this which is relevant to you, honestly. Even though the clause might be a page long, you just need to look at these items. One, you need to see what is the law that is being followed, whether it is being followed, what is being followed is laws of India and Arbitration and Conciliation Act 1996, or something with relating to Indian laws and which city, which laws of which city applies or which state applies rather. So that is one. So which law that is relevant. Why it is relevant is because if something goes wrong in the contract, the courts of that jurisdiction, that means that place, will have control over the dispute. You can file only in those courts, and then also the laws of that state will prevail. Okay, just for the process of it. And then another thing that you need to check is what is the law, that is what is the process that is being followed. Here the process that is being used is Arbitration and Conciliation Act 1996. But it can also be used, other processes can also be used. Some people use Mumbai Council of Arbitration process. Some people you can see using SEAC, which is your Singapore International Court of Arbitration, or London Council of Arbitration. There are multiple different arbitration processes that can be used. But be very, very careful, because those arbitration councils, especially those outside India, tend to be a little pricey. So depending on what what contract it is and whether this makes this kind of expenditure makes sense or not, you might have to choose that. Another thing which is also which will also trigger a higher expenditure is number of arbitrators. You can either have a sole arbitrator, which is the case in this particular clause, which then you have to ensure that it is mutually appointed, because if it is only one party appointing, then especially if it is not you, then you are at a then you have a downside there. Okay, so so if both parties are not okay with appointing a sole arbitrator, you can always appoint two arbitrators each. So one person will choose one arbitrator, the other person will choose another arbitrator, and then those two arbitrators will together appoint an umpire. So all these are up to you. Again, that will be more expensive because the number of arbitrators are increasing. However, it depends on the kind of contract that you're dealing with, right? So if it's very critical and then you want somebody to voice all of your concerns and all of that, better to have a double, 2-3 arbitrators. Otherwise, of course, if it's a smaller issue, sole arbitrator is fine. Now, these are just for arbitration. You can choose not to go the arbitration route at all. We have seen this in cases where, if you have very strong hold in one particular jurisdiction, you are aware of the case courts, you are aware of everything there. It might just be easier for you to just submit to a jurisdiction of the court rather than go through the arbitration proceedings altogether. So all of this, I'll just give you scenarios where this will become relevant. First of all, let's say you are entering into an agreement with blue-collared workers. Let's say you have a fleet of trucks and you are entering into agreements with the truck drivers. Okay. You can add arbitration clause, but I can assure you that might never be invoked, because a truck driver is never going to invoke an arbitration clause. Ultimately, what is going to happen is that he will go to a labor court. So it is better to just submit to the jurisdiction where you are more familiar with, where it is more applicable. Okay, so their arbitration clause doesn't really work, doesn't really make sense. But if it's like a service agreement, you are providing services to another party and you are based off Mumbai, and that person is based off, let's say, Hyderabad, then saying that you will be subject to the jurisdiction in Hyderabad and in the arbitration will be in Mumbai, and then arbitration will be conducted in Mumbai. Then what happens is that the other person sort of loses a little bit of an interest in filing a case against you, because he will have to travel all the way till Mumbai for each of the hearing and each of the proceedings. Okay, that is how you can also dissuade frivolous litigations. Another scenario here is that is when one party is in India. Let's say you are situated in India and another party is in the US. So of course the US party would be interested in conducting the arbitration proceeding, be it be arbitration or court proceedings in the US, and you of course would prefer Indian jurisdiction because you don't want to travel all the way to the US, and nor does he want to travel all the way to India. And another situation is also that another issue also in these cases are that you're not comfortable with the US laws, and nor are they comfortable with Indian laws, because they know that Indian courts might prefer or might side with the Indian party and US courts tend to side with the US party. So what do you do in such cases? Okay, so then you always have the option to pick a third party location altogether, a completely different location, which is a neutral location. So typically you can either choose Singapore or London and pick up SIAC or something as the process, and then you subject yourself to that jurisdiction just for the purposes of this agreement. So this process can also be done, which is usually the mid ground in such cases. But of course, it all depends on how you negotiate those contracts and how relevant those are for you. So how do you tailor DR clauses? First of all, location of the parties, where you are situated, where the other party is situated, and one of the major, your negotiation party, that really matters, because you should be able to tell the other person, no, I'm not okay with subjecting to that jurisdiction, and then you need to sort of fight for that and then give ample reasons why that needs to be done. Again, we discussed about the process too. You can choose which process to be followed, whether it is SIAC process, whether it is Arbitration Act of India, and all of those. And another critical thing is the language. This usually in Indian contracts, it is not so significant because both parties speak English, and it's usually kept as English in all the documents. But when it comes to offshore contracts, there might be other European, Japanese, Southeast Asian countries which even contract in languages other than English. So in that case, it might be relevant for you to have the language of the proceedings clearly mentioned. Lastly, the number of arbitrators, obviously, you will need to understand, you need to mention how many arbitrators are to be appointed. Otherwise, leaving it vague would make it very confusing later. Then there is the notice clause. I'll just, we would have always seen this. First of all, I'll tell you why this is relevant. Why this is relevant is because if you don't add an address, email, or phone number, whatever, the particulars of the notice, where the notice has to be served, the issue is that if you have to send some sort of a correspondence to the other party, and then you send it to the wrong location or the wrong place, then it doesn't get delivered. That means you have not served the notice properly. However, if they have provided an email address and everything in the draft, and then you serve it, then that means automatically that you have served the notice correctly. And then there are certain, if it is email, then as soon as it is sent, it is, and there is no bounce back email that you get, it is considered to be delivered. If it is address, if you are sending it by post, then the third business day is usually when it is considered to be delivered. So here also there are some scenarios where we should delve into. First of all, in case of an employment contract, we have always seen that there is a tendency to write the office email ID of the employee in the notice. So here, when you write the office email ID of the employee in the notice, the problem is that when you have to, let's say he has left the organization, you can't deliver the notice to the office email ID, your official email ID, because that person has already left the organization. So you'll need to always use the personal email ID of that employee so that it gets delivered to that employee even after he leaves. Because let's say he's taken some confidential information, you were not aware, you come to know about it 1 month later. In that case, how do you deliver the notice? You need to definitely have a personal or a address or something in such cases. Secondly, in case where a company has provided, let's say, regional office address, because a lot of companies have a registered office and other smaller offices, branch offices across, and then they have provided in the notice section that the branch offices where the notices has to go. Okay, But let's say one of your employees sent the notice to the registered office. Will it be considered as valid submission? It will not be, because the notice provided under the contract is the branch office. So it is always better to send it to the branch office and the registered office rather than just the registered office. Registered office is usually, address is usually used for correspondences from a governmental perspective and all of those things, where you have to where the government itself sends notices to the organization. So of course, how to create a notice section. You need, it's always better if every person has an address provided or an email address provided. But of course, a group of people, let's say a whole group, like a whole group of investors, one particular person is representing all of those people, then in that case, you don't need to have an address for everybody. If everybody doesn't want to separately be informed, you can just mention this one person has to get this document. The representative can be added as a notice party, and then you can share that. Okay. Secondly, whether it has to be always written, because you can see that in some places there will be phone numbers also provided under notice. Okay. While it is, it depends on the contract. First of all, it depends on the clause. If in the clause that we have given, it should always be given in writing. However, you can always avoid that language. But it is always better to give anything in writing, because there is no proof when it comes to an oral this thing. It is easier to prove written word rather than an oral discussion or an oral notice. So we have already how it will be deemed to be properly delivered when you are delivering it to a particular address as mentioned under the notice section. So another clause which almost all service and product related companies would know is the IPR clause, which is the intellectual property rights clause. So if you are the person who's delivering any contract for services and all of those, in that case you will be your IP will be sort of transferred to another person, whoever is paying for that. And then in most cases where you are actually creating something new for the other person, you may have to transfer that IP, because it is called a work for hire. Okay. So because that other person has paid money for you to deliver that. But this is mostly in case of customization, but there will also be like SaaS products and all where there is no customization involved. In such cases, all you will be doing is giving them a license. Okay. So here the thing is that then you need to make that distinction. You need to ensure that there is no other right that goes to the other person other than the limited rights of license to use and all of that. And in every case, pre-existing IP, that means any IP that was there in existence before this contract, which you have created independently of the contract, that should always belong to you. So these are the few things that you need to ensure that the document has. And I'll just take you through some case laws also, case studies also in this case. So let's say, so the example that I gave earlier was one person bringing in the money. That means the fees is paid by one person, and the other person is delivering the services or delivering the final product. Here, let's say both the parties are bringing in equal expertise or a little varying expertise and amounts. Okay. They're also putting in money into the development of a certain product. Then in that case, who will retain the IP, right? So here, the thing is that it is not that one person alone will retain the IP. Instead, what will happen is that both the parties can jointly hold the intellectual property. So when they jointly hold the intellectual property, what happens is that the thing is that you are equally holding. So both the parties. So you need to be very, very clearly. You need to clearly mention in the document that who can exploit the IP in what manner. Okay. So if let's say only one person has brought in just funds and the other person has put in created the technology. For example, let's say it's a grant. Okay, somebody has given you grant and then you are creating new technology. Okay. So here, the person who's given you grant may also want a bit of stake in that joint IP. Okay. So that would mean that that person can also use the IP while you also can use the IP. That's considered as a joint IP. but you need to set limits, because especially in case of transfer of that IP, transfer of that technology, you should not permit transfer without your permission, because ultimately what happens is that if you allow for transfer without your permission, that person could easily transfer it to a competitor, and then your IP would be ineffective at that stage. So that is one thing that you need to be very, very careful with respect to joint IP. Then the other scenario that we have come across is that in case like a company provides certain customized tools, right? Like, so when you create customized tools for somebody, I'm sorry. When you create customized tool for somebody else, there might also be some underlying IP of yours, because you would have created a base product and you're just changing some parts of it, some modifications, you're white labeling it or whatever the case is. In such cases, what part of the IP will belong to the other person, to your customer, and what part will be yours? Okay, so here the thing that you need to be very careful is that when you are delivering that, so whatever customization, we can say that that belongs to the customer. But over and above the customization, whatever is the underlying IP that you have generated independently, you should hold it technically. But the issue is that without that underlying IP, the other person cannot use, the customer cannot use the deliverable that you have given them. So here you will have to essentially give a license to all the underlying IP to the customer, while providing entire rights to the deliverable that you have given. Okay, so this has to be very clearly drafted and created, so that there is no breach of IP, first of all. Secondly, you don't overly submit IP to the other side, which is not really required. I think one of the things that we need to look for is that especially when you're creating customized tools, is whether you agree to exclusivity or not. So what happens is that when some customers in certain industries come to you saying that develop this software for me, okay, and they'll give you the specifications and everything, and then you develop that software for them. Okay, so usually as a software developer, what you would be thinking is that, okay, I know now that this is how it needs to be delivered. I can create this for others. I can pitch the same set of tools to somebody else. But in certain cases, the customer might require you to sign an exclusivity, which will require you to confirm that you will not create similar product for somebody else. So whether or not you can sign this, or whether it makes sense for you to sign this, depends on of course what your intention was before going into the agreement. But in any case, you need to be very clear in the agreement when you draft these. And if there is an exclusivity, then you'll be restrained from creating this for anybody else. Lastly, with one of the critical clauses is amendment clause, which we see in multiple all the agreements, because after signing a contract, if you need to make any changes to the clause, changes to the contract, then you will need to do it through the amendment clause, however the amendment clause is drafted. So in almost all the cases, it has to be in writing and both parties has to sign off on it. Okay. So of course, this is changing an agreement is a tedious process, because the signatories usually typically tends to be senior business officials, management officials, and all of those. So it takes a bit of time to get that through. Okay. But what happens is that your business decisions or the commercials may change overnight very quickly, and the business might agree, but still, because it is drafted into the agreement, it will be difficult for you to change, because then you will have to amend the agreement. Okay, so that is where the concept of change order becomes very relevant, because if you have just a purchase order, let's say, along with the agreement, where all the commercial clauses are taken care of, including fees, when you need to deliver, what needs to be delivered, and things like that, and only legal clauses are kept in the main part of the contract, you can easily change those commercial terms using a change order. And that you can make the change order process very simple. You can just say that this BU person can email the BU person of the other, or the contact POC of the other company, of the service company, and then confirm it through email and then get it through. So this is a very quick process where one person can shoot out a mail, the other person can confirm it, and it's done. You don't have to like again create an amendment draft, then send it to the other side lawyers. The other side lawyers will confirm it, then send it back. You'll make changes, you'll execute it on stamp paper. It's a long process. Better than that, you can easily do it through a change order. So here again, that's a scenario one essentially, where there are two parties and the annexure contained fees payable for the service. In such cases, after 1 year, let's say there is an escalation and there is no escalation clause in the draft, and then you need to amend the contract. What do? You essentially just go, if there is a change order process, you can go through the change order process. But if there is no change order process, this becomes difficult because you have to go through the entire amendment process where you have to get another draft executed by the manager, usually the managerial person of the both the companies, and then close this. Another scenario is that, let's say there is a service contract. It says that the deliverable has to be delivered within, let's say, 45 days or 50 days or 100 days, but somehow the service provider was unable to do so. So in this case, do you have to go back and change the agreement? You don't have to. This is not one of the reasons. Amendment is something that you need to do permanently. Like for you decide that not just for this scenario, for every scenario it is going to be, let's say, 100 days and not 45 days. Then you go back and change the amendment. But otherwise, all you need to do is that you just need to waive that requirement. Say it's okay, you don't have to do it in 45 days. Now you can go ahead and do it in 50 days or 100 days. So where do we use the change order structure? It's very it should be used only in case there is a commercial changes, but typically nobody uses it for a legal change because that will and should require management approval and not just business approval. I think that's about it from our end, and we are just towards the end of the session too. What we have learned, the key takeaways of the entire session was, basically you should now be aware of, how agreements are structured, what all you need to be looking into in each agreement, what is relevant, what is a flow, how to execute it, how to stamp it, what are the different types of agreement and when do you use it, and what you need to look in a contract, and what you can avoid and all of those things. And then, of course, we have also gotten some insight into what is some commonly used clauses and what you will encounter quite frequently. Now you can just I open the session to actually for taking up questions that you may have had over the course. But before that, I'll just quickly let you know that there are more sessions that is coming up. The next session that we are planning to do is on how to handle notices. So we've seen in multiple cases that there will be notices that is it could be government notices or contract based notices where one of your customers or your vendors have some issue and they will send a notice. It might end up with in the security guard's desk, or it might end up with one of the employees, they might have accidentally put it inside and then you've forgotten about it. So you need to definitely prepare your employees how to deal with it, and even if after knowing that you've received a notice, what do? What are the next steps that needs to be taken, and how do you respond, and what to do and what not to do while responding notices. All these will be covered in the next session. Yeah, no.
Thanks, Sarvi. Yeah, how's open for questions if anyone has any query? In the meanwhile, Sarvi, I just take up one query which has come while through the registration.